So, give you some general information. If there's anything that we're missing, any specific questions that you have, feel free to let me know. Um, so, estate planning generally is, you're thinking about, it's not just about the stuff that you have, it includes that, but it's also about um, incapacity planning. That's just a, you know, overall term for what happens while you're alive if you become, get dementia or um, some other incapacity where you need someone to do things on your behalf, take care of banking, to take care of your healthcare decisions, um, figure out how to get logged into your email account so that you can respond, figure out how to get logged into your financial account so that you can pay the mortgage and do all those things. That's all part of it. It's, estate planning is such a huge category that continues to grow as the different types of issues that you got to deal with grow. So another big component that we're talking about is this digital assets planning. And digital assets includes more than just cryptocurrency. We're talking about all the things that you have to log into, all the passwords, all the usernames, all the emails, Facebook accounts, Instagram, all those accounts that have to be dealt with. They may not have particular value, or they might be a situation where you're married and one spouse handles certain things, another spouse handles other things, and the spouse that handles the financial aspects passes or for whatever reason can't handle them anymore. So you've got to make sure that you've written down, given the instructions, and made it possible for that other spouse to be able to log in to your banking and do all those things. So again, these aren't things that necessarily have value, but they're things that you don't necessarily want to leave out there for cybersecurity issues, things that you might want to, your social media accounts. You may want to download all your information, all your posts, all your media, your pictures, your videos, all those things. It might be important for your family. You'll hear us talk a lot about legacy planning. It all wraps into one big blanket of, what do we need to do for the next generation, for our relatives, our family, our heirs, to make sure they're taken care of, to make sure our legacy, our history, what's important to us carries on. We create, we have the ability to create. That's the broad overview. That's the 40,000 foot overview of what this is about. So there's, I figure a good place to start. We've recently been working on updating our website, kaplanlawfirm.us, and hopefully all good. Okay, that's good. So hopefully the video is fine. So if you go to that website, there's still under development, but there's still a lot of useful areas under the estate planning. We've got a list of the types of services that we provide, and there's also a list of frequently asked questions. And so I figured this would be a good place to address some of those. So there's, not everybody is ready to do the entire estate planning spectrum at one time. It's a big job. It's doable and manageable, and we do what we need to make it so. But it can be overwhelming, and we try to come up with some additional ideas for how you can get started. So, what are if I could only do two things, the two things that I would focus on: first, make sure you have a durable power of attorney. That's probably one of the more useful documents that you're going to need. It's included in our estate planning packages, but we can certainly carve those out and make those happen. But the other thing that probably has the biggest impact is called a ladybird deed, also referred to as an enhanced life estate deed. And its primary purpose is, when you own a home, is to make sure after you've passed that it transfers to your heirs, your beneficiaries, without the need for going through probate. Probate is essentially the process where once you die, if you own assets in your name, you have to go through court, have a court appoint somebody to manage the assets, distribute them. So it's not a difficult process. It can be lengthy. It can be somewhat expensive. So you hear people talk about, oh, it's important to avoid probate. And this is one of the primary ways you can do that. There's a lot of ways you can avoid probate, and surprisingly, you don't even need a trust to do it. That's one belief that I have to correct people on, is trusts can be used to do that, but it's not needed for the most part. Most of your assets can be, you can title them, you can add beneficiaries, you can do what you need to keep them out of probate without using a trust. And so your home or whatever other real estate you own, the Ladybird deed is one way to do that. It's transparent. It doesn't impact your homestead exemption, your homestead taxes. It has no impact whether you have a mortgage on it or not. You're essentially transferring the title to you and your spouse for life. That's called a life estate. And once you've passed, that automatically by law transfers to your beneficiaries. So if you have adult children, you would leave it to them directly in the deed. If you've got minors, you would typically set up a trust to serve as the beneficiary. But it's a seamless process, relatively inexpensive, and for the most part, when somebody passes, their biggest asset tends to be real estate, and those are the assets that you typically want to move the quickest. And if you have to go through probate, it's just not going to happen. So it's an easy thing. You definitely should include it in your overall estate plan, but if you're only looking to do certain parts, this would be a good place to start. The other question we get a lot is, what's the difference between a will and a trust? So every estate plan needs to include a will. There's a basic set of documents that you include, including a will. The will is where you specify who's going to manage the assets after you've passed, who's going to serve as the guardian if you have minor children. It's where you put who's going to inherit everything, your spouse if they survive you, or your children in equal shares. If you just have a will, then by definition you're going to have to go through probate. Like I said, we can typically title your assets and make other tweaks to your financial aspects so that you don't have to go through probate. So even if you just have a will, a lot of times you can avoid probate by taking the proper steps ahead of time. The will is essentially a fallback. It's a catch-all to in case there are assets that you missed, forgot to title, or did something that ultimately ended up to being wrong, and now it has to go through probate. So that's where that is. Plus, when you're dealing with guardianship issues, that's one of the places where you would specify those aspects. So a trust, on the other hand, and a will only takes effect once you've died. Once you pass, that's when a will takes effect. A trust takes effect immediately. It's essentially, an agreement, it's a contract, it's a bucket that you put things in, and you get to specify how those things are managed while you're alive, how those things are managed after you've passed, and how they get distributed. So it gives you a much greater range of options, much more flexibility in how your assets are distributed. So if you have minor children, if you've got children with special needs or other heirs that have issues, that it would work best if somebody managed the assets and distributed them over time in intervals. That's how a trust works. You can set it up so that assets can be managed during your lifetime. That's called lifetime funding or lifetime trust, or you can do it so that everything transfers to the trust automatically at death, and that's called a testamentary transfer. Either way, it's a function of what you're ultimately trying to achieve, what your needs are. For example, if you're aging and anticipate that you're going to need help managing your assets, then putting them into trust may be best. You still have your power of attorney. You still have your other ways of granting powers to other people to do that, but it often works best and it's often easier when assets are in a trust. So a lot more issues, a lot more things to talk about on the trust aspect of it, but we do deal with those on our website, and certainly I'm happy to chat with anybody. Another question we get a lot of times, you own a home, a lot of times it's a single parent, they have a child and they want to add their child to the title to the property for estate planning purposes. They are, want to make sure that the home goes to their child without it having to go through probate. So that's what they ask. They call and they say, I want to add my child to my deed. And so after running through a series of questions, ultimately what we conclude is that they're just trying to make sure that the child inherits the home without having to go through a big hassle. So that brings us back to the Ladybird deed. So typically that's how we solve that issue. We don't like adding children. A lot of times, we don't add children for a few reasons. One of the primary reasons is for tax purposes. There's something called a capital gains tax, where when you sell your property, you have to pay taxes based on the difference of what you paid and what you sell it for. So you may have bought the property 20, 30 years ago. It's now worth 10 times what it was worth. If you put your child on the deed today, when your child goes to sell it, their starting point is now going to be that high number. If you wait and transfer it to them when you die through a Ladybird deed, they start they start at the bottom. They start where your basis left off. So it's called a step up in basis. So that essentially eliminates any capital gains tax. Another reason we don't put children on the deed now is it can impact your homestead exemption. It now makes it impossible for you to do anything, whether it's sell it, refinance it, or what have you, without your child being involved, consenting, etc. A lot of times parents will want to put a minor child in title, which you can do that. A minor can own real estate. They just can't do anything with it. They can't agree, make decisions. They can't sign anything. You'd have to go through a guardianship. It's not a good scenario. So we don't usually do that, or if we do, we certainly discourage it and talk about the need for a trust or Ladybird deed. So, question we often get: people moving in from out of state. They've already got estate plans set up from out of state, and they want to know what they need to do. Are they enforceable here? So, first answer is, if Florida does have reciprocity. If your documents were properly executed and they're enforceable in the state where you created them, then they'll be recognized here in Florida. Few issues. Generally, you want to have estate plans in the state where you own assets. If you've moved here, you're most likely going to have moved your assets here. You're going to be buying real estate here. And even if the documents are enforceable, they may have different terms. They may do them differently. So first step is to send us copies. We review them, and then we'll discuss all the options. We'll let you know. We'll confirm that they are enforceable. We'll confirm where we think they can be improved. We'll even let you know if we think they're fine. A lot of times we still end up adding a Ladybird deed because Florida is one of only a few states that actually has those. Other states do have transfer on death deeds, they're called, but they're far more limited and restrictive. So Florida is a great place for that. And if you have questions, feel free to comment. Otherwise, I'll continue just giving you a little summary. So what happens if you die and you don't have a will or a trust? So when you die, if you have a will, it's called dying testate. If you die without a will, it's called dying intestate. If you don't have a trust and you own assets, again, whether you have a will or not, if you've set up all your accounts insurance policies, retirement accounts, IRA, bank accounts, all those things. If you've added the appropriate payable on death beneficiary for, say, bank accounts or beneficiaries and contingent beneficiaries to your investment accounts, if you've set up all those things properly and you've put your home in a ladybird deed and you don't have minor children, then there isn't a lot of need for having a will. Most people won't have gone through that process without actually having met with an estate planning attorney, and so you're going to have a will anyway. But my point is, if you set things up properly, there's, in my opinion, very little value in having the will. But anyway, if you do have property in your name and you have to go through probate, there's not a material difference in terms of costs or the time frame for probating a testate estate with a will or probating an intestate estate where you don't have a will. So that's no reason to not have one, but in the event that you did have one or didn't have one, or you did have one that wasn't properly executed or for some reason it wasn't enforceable, that's just some peace of mind. Plus, if you do have assets that have to be distributed through probate and you don't have a will, then the statutes dictate what order your heirs take. For example, spouse first, then your children, then your parents, then your siblings, etc. So there's a specific order in the statutes if you don't have a will, which theoretically is going to be very similar, if not identical, to what most people would have put in their wills anyway. So that's why it's something that's good to have, but it's not going to ultimately cause too many issues most of the time if you don't have one. All right, so let's see. So the durable power of attorney, this is one area, for example, when people come in from out of state, or even from other attorneys, we have people come in to have their estate plans reviewed if they've had a long-time attorney that's no longer practicing. But one of the areas where we can generally improve is the durable power of attorney. My philosophy is more is better. The goal with the durable power of attorney is to make sure that you have as many powers and flexibility in there for your attorney. In fact, that's the person who you've appointed to act on your behalf, to do whatever's necessary to take care of things. The last thing you want is to be in some situation where you need to do something, get something, ask something, and the person says, well, unfortunately, what you have here isn't sufficient. So we try to draft it in such a way that can't happen. And it's extensive, it is comprehensive, and it can be overwhelming, but we try to make that process easier. We go through it, we give you the key to understanding it so that you're comfortable that it's the right thing for you. But that's why I think that's one of the other two, along with the ladybird deed, things that are important, because other than death, the only other thing that's likely to happen is either you become incapacitated in some form. It doesn't necessarily mean that you are in a coma or that you have dementia, but you could be out of the country for a while and you need somebody to do things for you. You don't have to be incompetent for a durable power of attorney to be useful, but the durable power of attorney remains useful if you do become incompetent. That's the durability aspect of it. Estate plans, updates. Well, if you are the smart few or the lucky few so far to have estate plans in place, it's important to review them periodically, maybe every few years, but at least whenever there are major life events, births, deaths, marriages, divorces, you name it. Taking care of, becoming a caregiver for a relative. Anytime these things happen, it can change the dynamics and it can change how things are set up. And if you haven't reviewed it, then it's not something that you can address. Bank accounts. What happens to my bank accounts when you die? Well, I mean, that's what happens when I die? Well, it's such a loaded question, such a broad question, but I think ultimately what's being asked is, if I have a bank account in my name and I die, what happens to it? Well, if you've planned ahead of time, you've designated what's called a POD, payable on death beneficiary. That's how the bank accounts are set up, and it allows you to specify who gets the account, who gets the money in the accounts when you die, so they don't have to go through probate, and it avoids a lot of hassles. And there are things that we help you think through, whether it makes sense to add an adult child as a co-owner now. So it can certainly make things easier. You can add them as third-party authorized people to call and get information. There are things that you can do now to make things far less of an issue for your children and for the folks that are going to have to handle the estate planning issues when you pass or when you become incapacitated. That's one of the primary reasons that bring at least half of the clients that come in for estate planning. They've either recently had to deal with a parent's death and their estate, or they've had a sibling or a friend. But once they've personally experienced it or know someone who has, they understand the depth of the need for a proper estate plan. Disinheriting people or leaving different amounts to your children, can you do it? You can. The key issue is making sure that your intent is clear. What you don't want is to leave someone out that would ordinarily you'd expect to be in there. So if you have 3 kids and for whatever reason you've chosen not to include one of them, you at least want to mention that they exist and mention that you're not including them and it's intentional. You don't have to explain it. You just need to make it clear that it wasn't an oversight. That will avoid a lot of disputes, a lot of issues potentially down the road. So you can do that, and even if you have 2 children, one of whom is done very well in life, really doesn't need the money. You can leave different percentages depending on your family dynamics, your family needs, that sort of thing. So that covers the frequently asked questions. There are a lot of moving parts. A lot of people ask, how do you know what you need? Well, that's certainly where I come in. The process includes, asking a lot of questions, whether you're, obviously married, whether you have a blended family, children from a prior relationship, that can really change the dynamics. Whether your spouse was recently diagnosed with dementia, whether whatever the questions are, whatever the answers are, rather, it'll help us figure out whether you are a will-based estate plan where you've got all the general, you've got a will, you've got the incapacity planning, which includes the durable power of attorney, a healthcare power of attorney. We include several other documents in there, but or a trust-based estate plan that includes a trust in addition to the basic will packages. And the trust is that's the part where the details matter. There aren't a whole lot of scenarios that we work with where trusts are useful. They're certainly more expensive. They add they add a material cost to the overall estate plan, but sometimes it's unavoidable if you're looking to have everything set up properly. So if you have minor children, it's a must. If you need to vary or plan or dictate or tweak how you leave assets, how you leave things to your heirs in any material way, any significant way other than to so-and-so in equal shares. A trust can often be important. If we've had clients come in that are going through some health issues and may very well need help during their lifetime managing their assets. That's where a trust can be helpful. You would fund it during your lifetime. You would retitle a lot of your assets. You would change your bank account, for example, to be the name of the trust. You would change your investment accounts, not your retirement, but investment accounts, to also be in the name of the trust. And what this does is it allows someone you designate, called a trustee, to manage those assets for you. Generally, it's you while you're alive and capable, but then you have successor trustees that step in when you need. It keeps issues out of court. It keeps your estate private. Keeps you from, most of the time, having to go through guardianship proceedings. It avoids a lot of the issues that you don't know you have until you're presented with them. So probate, that's another area that we've started with. I've done some probate over the years, had put it aside for a while, but now we're back in it. There's two primary kinds: summary administration and formal administration. Summary administration is very simple. It requires that you meet certain conditions. Probably the most common condition is if the estate that you're looking to probate, if the person has been deceased for at least 2 years. If it's been more than 2 years, then the size of their estate isn't relevant. If it's been less than 2 years, currently, if their estate is valued over $75,000, and I think they're going to up that to $100,000, then it has to go through a formal probate, which is far more lengthy, far more expensive, and just has a lot more elements to it. So, if you've got relatives that have been deceased for a couple of years and you're now having to deal with some assets that you've discovered, that is a good scenario for us to handle for you. Formal administration, if they're simple, you don't expect any contested, any of the heirs to contest it, disgruntled siblings, whatever the scenario. Straightforward, simple, that's kind of our niche right now. We will leave the complicated stuff to the others out there. And on the website, we also talk about, obviously people want to know what this process looks like, how long it takes, that sort of thing. So it's an 8-step process. I could have made it 15 steps, I could have made it 4 steps, but you reach out to us, we send out initial intake email, get some general information, which will then allow us to either set up another consultation to talk about the specifics. We'll put together a proposed plan for you, explain why we chose that. I'm very cynical, so my first thought is going to be, well, of course they're going to recommend that because that brings in the most money. But I'd like to think that, you get to know us, but that's not how we move things along. We're going to give our recommendations based on what's best for your scenario. We'll explain it. We'll defend it. Even if it's, a lot of times people come in and they tell us they want a trust, and we ask why. What are you expecting? What's the goal here? And then when we find out what they're looking to do, such as keep their home out of probate, we let them know, hey, good news. You don't need a trust. You just need a ladybird deed. So we do that. And it's important that our clients understand that and trust our recommendations. If it's still something that is outside the budget, that's fine. That's certainly a legitimate reason to put things on hold for a while, but don't go into it thinking that we're out to get you. We're here to help. But ultimately, once we've given you the recommendation and we've gone through it, we've explained it, we'll chat with you again, see if you have questions, any follow-up information that we need. We send out an invoice, email it for electronic payment to get the process started, and then we send out the At some point during this process, we've sent you a worksheet with a lot of detailed questions, and that's where we get the information about your heirs and other beneficiaries, your appointments, who you're going to have serve in these different capacities. And we have information that we send you that helps guide you along those questions and explains what type of person you're looking for in these roles, what qualities they need, what they're going to need to be doing. So it'll help you in that decision. We prepare drafts, send them to you for review, along with a review guide, which essentially says just review these very few sections, confirm the information. We also send out a more comprehensive guide for those of you who like a little light reading at night. That goes through everything in detail. Once we get comments back, any revisions are tweaked, and then we set you up for your signing appointment. It can happen as quickly as a week. Sometimes takes a few weeks. A lot of it is driven by your responsiveness and how quickly you want this to move forward. But we can typically move as quickly as you need. The website also includes a list of our typical estate planning documents. And, again, my guess is our packages include a few more documents than most. I think lawyers are known for, if you can do it in 2 steps, then we might as well do it in 3. So here we've got 3 or 4 documents which have a good bit of overlap, but they serve unique purposes. So for example, the healthcare, we have a variety of different forms dealing with complete incapacitation, temporary incapacitation, healthcare surrogates for your children if you need to, temporary medical consent. All of these things have different roles. Some of them come into play before incapacity, after death. So there is a rhyme and a reason to it. We'd rather be overly comprehensive and cover as many different areas. Certain things that you need, the providers of that information or service may require a particular document. So that's why we give you the options. And digital assets, as I mentioned, is a huge thing. It can be, we just recently did our own, oddly enough, being an estate planning attorney, it took a while for me to get mine final updated with all the new gadgets and bells and whistles. But my goodness, it certainly opens your eyes to how comprehensive it is and how overwhelming it can be if you don't take it in small chunks. And we help you do that. We help you break it apart into manageable segments, manageable conversations. We're trying to eliminate all the barriers that people come up with for not doing their estate plan. So we'll keep pushing and hopefully we'll get the word out. But this walks you through some of the primary documents. Once everything is signed, we make copies for you, make a couple copies. We'll give you the originals. We don't hold on to those. You should keep those in a fireproof safe. Just make sure that somebody knows how to access it. And we generally recommend that anyone who has a role, whether they're going to be your attorney in fact or a healthcare surrogate or even beneficiaries, that they have copies of the documents that they're involved with so that they know what their role is and when they have to step up. So that's what we've got for now. I think I've covered most of the questions. I think I will probably, we're also adding this website thing. I tell you, I don't know if any of you out there have designed websites. I love it, but oh my gosh, it's so consuming beyond comprehension. And so it continually grows. Anytime I make one thing, I go, ooh, let's do that. And then 2 days later, I'll delete that and add something else. So it's an evolving website, as I'm sure most are, and we are adding documents. Things. We're going to be adding articles. I deal with these, daily, dealing with clients, answering questions. Just as you read, you come up with new scenarios, like, oh wow, well, what if this were true, or what if this were the case? And these are questions and issues that our clients deal with, so we'd like to make them available. So we're putting those together. It's a slow process, but we're getting those uploaded. We'll let you know. We're going to highlight certain aspects of the website. We're going to, certainly take feedback and try to make it as useful of a place for you folks to go. I think that's about it for now. So you know where to find me, hopefully. Stephanie, who got all this set up, she's great. Hi, Stephanie. And she's the, among other things, the marketing guru, the enforcer, I don't know, you name it. But she handles a lot of the initial intake and a lot of the questions, and so she understands the process and is been a great addition. So we're happy to have her, and hopefully we'll hear from you folks soon. And if you have questions, if you need information, you can just go to our website, click on the Contact Us button, and it'll take you to an information sheet. You can either email us directly, or with a few clicks, it'll send me an email with your question, and I can respond, and we can get started. So no phone calls needed. And hi, Emma. There she is. Hi, Emma Record. Thanks for joining. I know we need to do this again. Emma and I did a Zoom event on her Oviedo group. I think it was my first in a long time. I used to do these quite a bit, and then life took over, but I actually enjoyed it. And as much as I was fighting this, hey, who doesn't like talking about stuff that they know? So anyway, this I'm assuming will be a video that will be enshrined in the records of Kaplan Law Firm for as long as Meta allows it to be. And I'm always around for other information and can answer your questions as you need. But thanks again, and I will sign off now. Have a good day.